courts.
This is not a normal court.
There you have it. Nicole Wallace mentioned earlier one of the more newsworthy things the president said today, discussing the legitimacy of a court that now has rebuffed decades of precedent, but only on certain issues like women's rights, health care, abortion, affirmative action today, and that affects the rights of all Americans. The justices' actions on the bench cut against what they've said when questioned in their confirmation hearings.
As a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent.
Well, of course, the inquiry begins because there's been some argument that the precedent was wrong. But that's not enough to justify an overruling.
Operate as judges when they're confined by the law. They're constrained by the words of the Constitution. They're constrained by the precedents of other judges that become part of the rule of law that they must apply.
If judges were just secret legislators, declaring not what the law is, but what they would like it to be, the very idea of a government by the people and for the people would be at risk.
Precedent on precedent. You can't just overrule precedent because you might have decided it's wrong or disagree with it, and you can't become a super legislator. All of those things you just heard, all from people who said those things under oath, but are part of this ruling today, and were part of the ruling overriding Roe. Roberts Court is undercutting certain precedents over and over, even recently reaffirmed ones. And then there's the ethics scandals that also have a very real impact on whether the country thinks it should give such deference to, say, the two individuals you see on your screen who are blatantly pocketing sometimes not only far more money than most people make in a year, but in some cases more money than they make in a year, which makes you wonder, who does Justice Thomas even really work for? This is an institution increasingly out of step with the rules that it requires others follow, with basic procedural safeguards, norms, and transparency, as well as contradicting its own stated values that Roberts, chief among all of them, has argued. Precedent and the law guides this place, not just the members and their personal opinions of whoever happens to make it onto the court. For this wider look at tonight's ruling and the wider issues, we're joined by the New Yorker's Jelani Cobb, Dean of the Columbia School of Journalism. Welcome back.
Thank you.
We understand the skepticism that people bring to many issues in America. I think it is true that historically the Supreme Court has operated differently than, say, the political branches, where there is rank trading, rank tricks, leaks, all the other messy stuff we know about. And at times, it has even gone and taken risks to advance or protect civil rights. This feels like a different court today. Nicole and I discussed that. I showed some examples. The president mentioned it. Do you think it's a fundamentally different court today?
Listen, there's always been, a degree of concern about it, not nearly as much as there is right now. But you did have the possibilities of things like, the classic example, Earl Warren, who oversaw, in addition to Brown v. Board of Education, a number of other, legal precedents on the Supreme Court that people thought, liberalized American society, certainly liberalized American jurisprudence. But he was appointed by a Republican president, Eisenhower. And the most distinct thing that people knew about Earl Warren prior to him arriving on the bench was that he had overseen the internment of the Japanese in California during World War II. There was nothing about him that suggested he was going to become the kind of avatar of liberal jurisprudence that his name is now associated with. The possibility that people can intellectually grow and develop, they can follow their intellect, their consciences on the bench seems to be foreclosed, because if there's not a one-to-one relationship between Republican prerogatives and priorities, it's pretty close. There's a pretty close ratio of those two things, which serve to delegitimize the court in the eyes of the public. Last year, the polling showed that the public had the lowest view of the Supreme Court that had ever been recorded. Just 47% of people said.
We'll put that up. I think we have
Yeah,
that
just for
sloping
the-
line as you continue. We'll show
Yeah.
that.
And so the impact of that, is when we're talking about the polarization in society, you really, really need a judicial branch that is above the fray. That is decreasingly possible right now, in the moment that we're in.
Exactly. I think you lay that out. And Jelani, what we heard there in the testimony that I played matters because there are justices, including historically some Republican appointees, who would say that just because the composition of the court changes and you now might have 5 votes for something does not mean you rush to overturn it. Quite the opposite. That
Right.
While they have their views and they have their history, that if the court becomes just a late echo of politics, then it's nothing, and you don't need a court. You certainly don't need another 9 people just redoing politics, right? The entire structure is supposed to be different. And so we showed that this affirmative action case was recently upheld, that the only thing that changed is they added the Trump justices to join Roberts, and the court was in a rush to take these cases. As I've reminded viewers, they have many avenues to say, that's decided, we're not taking that. We just reaffirmed affirmative action within the decade. They didn't need to even go down this road. They rushed to do this like they rushed to go at Roe. And my question to you is, what happens in a society where the third branch that's supposed to be above it all is equal or below it all with lifetime tenure and at least abuse of discretion, if not power? Where do we go from there?
So, the founders, people have talked a great deal about the founders of this country and their idealism. But, there was a certain skeptical idealism, if it can be called that, or a cynical idealism. Because, when you go back and read Madison and, the Federalist Papers, that is a very sober-eyed view of human nature. And what you get from that is the idea that if your institutions don't work, if these things, this scheme that's been put together in the Constitution doesn't work, people will revert to their previous behaviors, which tended to be violent, which tended to be disruptive, chaotic. And so you have to have institutions that people place faith in, that they can place faith in, that are above reproach in their integrity, which is what ties also, by the way, the partisanship of this decision to what appears to be corruption in the behavior of the court, or at least I'll say questionable ethical behavior in the behavior of, in what we've seen of the justices based on the reporting the last few months. And so all of that cumulatively erodes, as it reasonably would, erodes people's faith in this, the ability of this institution to serve the function that is prescribed.